CCJ Appeal number CR1 of 2006, the Queen versus Mitchel, Ken O'Neill Lewis.
Please, Your Honors. In this matter, I appear for the appellant, and with me, my learned friend, Mr. Elwood Wallace.
Please, Your Honors, in this matter, appear on behalf of the respondent, the Association with my learned friend, Mr. Bryson.
I understand that we are without the benefit of air conditioning, and I apologize for the resulting discomfort. But it will be an inducement, I suppose, to brevity. So there's always some advantage to be derived from even adverse circumstances.
I'll be guided accordingly.
Yes, Mr. Debo.
May it please, Your Honors. This is an application by the prosecution to seek leave to appeal a decision of the Court of Appeal given on the 5th of January this year. Pursuant to a case management conference earlier this year, it was ordered by consent that two issues should be argued before the court before one gets to the merits of the case. Namely, it was on the 4th of October, the case management conference ordered that the two preliminary issues should be: one, whether by virtue of Section 6C of the Caribbean Court of Justice Act, the Crown has an appeal as of right to the Caribbean Court of Justice in this case, and two, whether if such a right exists, the Crown can, as part of any relief it claims, secure the reinstatement of the conviction of the respondent. The Lords, very briefly, I do not propose to deal with the facts of the matter if that is convenient to the court. By way of background, I propose to deal directly with the arguments on the two preliminary points, if that is convenient to the court. But by way of background, it was a conviction for murder in which the appellant, if I just refer briefly then to the summary of facts, that on the 8th of June 2000, the deceased was shot. The case for the prosecution was that he was shot by the respondent. On the 8th of October 2003, the respondent was permitted to stand trial at the January Assizes of 2004. And on the 16th of January 2005, the respondent was convicted of murder, and he was sentenced by the trial judge, Mr. Justice Moore, to death, which is the mandatory sentence for this matter. On the 21st and 28th of October 2005, the appeal was heard in the Court of Appeal. And on the 5th of January 2006 this year, the Court of Appeal quashed the conviction and ordered a retrial. It is from that basic background that this appeal and the preliminary issues arise, my Lord. Namely, that the Court of Appeal in that case found that there was alleged unfairness in the trial, in that an application for the recusal of the judge was made in the presence of the entire jury pool, and the Court of Appeal was of the view at paragraphs 22, 28, and particularly at 29, that application, namely the application for recusal of the trial judge, should have been heard in chambers or in the absence of the jury pool, notwithstanding the fact that no such application or request was made for the trial judge to hear this matter in chambers. And based on that, the Court of Appeal came to the conclusion in paragraph 29 of its judgment as follows. paragraph 29 of its judgment on the disposal, the Court of Appeal said, we have considered the first ground of appeal in light of the overall fairness of the trial and the other grounds of appeal. We conclude that the cumulative effect of the matters raised in the appeal, taken together as a whole, was to deprive the appellant of a fair hearing interpreted in accordance with the Constitution, such as to render the verdict unsafe or unsatisfactory. If a conviction is to be upheld as safe and unsatisfactory, it should have resulted from a trial in compliance with the rules of good practice and the high professional standards established for criminal trials. The right to a fair hearing in the criminal case is absolute. That was the government of the Court of Appeal's finding on, in conclusion, in coming to the conclusion that it came to, that the trial was unfair, as interpreted by the Constitution.
How do you interpret the words, the matters raised in the appeal, taken together as a whole? Does that mean that they were referring to matters other than the what was said before the jurors in the course of the application for recusal?
I think, in fairness to them, that they could have been referring there to the all the other grounds of appeal, because if you notice from this decision, they've only they've only dealt in detail with one ground of appeal, and there would have been about 8 grounds of appeal argued, but they never bothered to refer to any of those. So, in fairness to them, I'm assuming that is what they meant there.
But how? But did they? What are we to make of that? Is it that they considered there was some substance in those grounds, or which of them, or was it all of them, or because there is no reference, no other reference in the judgment to any other ground of appeal.
Indeed, and that was one of the points I had intended to raise if and when I get to the merits of this appeal, because they have completely ignored the other matters, and this is the only bland reference to it. The other grounds, and one can only surmise, and I have to surmise in their favor, that they were referring to having considered these other grounds. But there are decisions which say that you shouldn't, that the Court of Appeal should really respond to most of the grounds. And that is one of the points I'd intended to raise if and when, my honors, we get to the merits of the matter. But suffice it to say that the other way I can look at this is to say this is really very nebulous as to what they're really referring to, because I can only speculate as to what they are referring to, with the greatest respect, my lords.
And why was it, do you know, that this case took, some 5 years to come to trial? You know?
My lord, yes. As you would notice from the case record, the offense allegedly occurred in June
2000.
Yes, the respondent was arrested months later, and in Barbados, regrettably, despite we have short-form committals, most lawyers still use the old-style committal, in whereby they get 2 bites of the cherry, and that you get a chance to cross it, and that tends to drag out most preliminary inquiries for quite a while, because each witness is subjected to cross-examination, and then it's many times cases are adjourned. A witness gives evidence, and the witness has to come back to court when counsel is available, if he's not available. I'm just saying this by way of general comment, but I cannot specifically tell you that this actually happened in this case. Suffice to say that that is the usual culture. That the preliminary inquiries, as you notice here, it was...
Yes, I know that that's...
So, 3 years.
Is 5 years average time for this, for a case to reach trial, to come to trial?
Yeah. it is not the most satisfactory solution. But as you would see, when it came to the Director of Public Prosecutions, he was tried at the very next assizes as soon as possible. I mean, he was committed on the 8th of October, and we have, at that time, the assize system. So if you're committed on the 8th of October, the October assizes has already started. The next possible assizes you can be tried at the earliest is the January assizes.
Well,
And he was tried at the January assizes.
Surely he wasn't tried in January 2006, was he? I think you got your years of experience.
Yes, sorry. Yes, he was tried he was tried 2 years later, and for the reasons which are obvious in the record, my lord, there was a change of several lawyers, and that is what had protracted this trial, because that is one of the principal points made in the merits aspect of this case, namely that the accused had changed several lawyers, and that had not allowed the case to come on. I'm much obliged, my lord. If therefore I may proceed with to answer the preliminary questions posed by the courts to me in the
Yes.
case management here,
Please, go ahead.
by way of background. Thank you, my lords. The appellant is contending that we have the right of appeal on several bases. One, we're contending that that we have a statutory right to appeal, and that statutory right exists under Section 6C of the 203 Act. That section is before your lordships, and it is as clear as it can be, in that Section 6C provides that an appeal shall lie to the CCJ on a point involving the interpretation of the Constitution. We say several things on that, my lord, your honors. One, that this is an express statutory section that clearly provides to each party in a criminal matter, namely prosecution and defense, the right of appeal. Why do we say that? One, we say that, my lord, your honors, on the basis that the legislative parentage of this section, namely Section 64 of the Supreme Court of Judicature Act, Chapter 117, provided for such a right, as in Section 64, Section A, subparagraph 3, provides that appeal, this was a former section that is now repealed and replaced, we argue, that appeal lies from final decisions in any civil, criminal, or other proceedings that involve a question concerning the interpretation of the Constitution. My honors, it is the submission of the appellant that this section, formerly Section 64, which has been repealed and replaced by Section 6C of the CCJ Act 209 of 203, simply restates the Crown's position as well as the appellant's position of the statutory right we both enjoyed to appeal to the highest court. This is substantially different, with the greatest respect, than what my learned friend contends, that appeals are only regulated by the Criminal Appeal Act, and that an appeal under the Criminal Appeal Act means an appeal to the Court of Appeal. Indeed, that is correct in large measure, if you're dealing only with an appeal. But the very Criminal Appeal Act of Barbados, in Section 37, if I may draw it to your attention, it's, I think, tab 2 of Respondent's Bundle, not tab 2, sorry, but Criminal Appeal Act of Barbados, that would be tab G, sorry. Tab G of Respondent's Bundle. If you join me at Section 37 of tab G. It provides as follows.
Yeah, all right, go ahead.
It provides that for appeals to the Privy Council, And it says subject to 38 and 39, an appeal to Her Majesty in Council as of right from from a final decision. Yes, from a final decision in any criminal or other proceedings that involves a question as to the interpretation of the Constitution. This is Section 37. My honor. This.
Mr. Leacock, I speak now only for myself, but it seems to me that the really formidable hurdle you have to cross is is to show that this appeal involves a question of interpretation as opposed to application of the provision in the Constitution concerning a fair trial. And it would appear to me, and I emphasize that it's, I speak only for myself, that it'd be difficult to distinguish this case from Pereira and the Attorney General of Ceylon. I think that the point that you are arguing now, that it is open to the prosecution to appeal under this action, is one that one might concede at any rate for the purpose of getting to what I can conceive to be the real problem that you have to confront.
I'll be guiding accordingly, my lord. Therefore, I'll take my time and address you on the issue of the interpretation point.
But just before you do that,
Thank you, my
is
lord.
there any relevance to the fact that in the interpretation section of that Criminal Appeal Act, Section 2, appeal means an appeal by a person convicted upon indictment?
Yes, my lord. The relevance of that is only that relates only to the Criminal Appeal Act when you're appealing from the High Court to the Court of Appeal. That's the only relevance of that. And that is why I was just drawing this court's attention to Section 37, which expressly provides for an appeal outside of the Court of Appeal to the highest court, which is Privy Council, and now to this honorable court. So in Section 2 of the interpretation section of the Criminal Appeal Act, it refers to an appeal meaning an appeal to the Court of Appeal. But that is only when you're dealing with the Court of Appeal from the High Court. What we are at this moment, we are beyond that.
Why do you say it is limited only to the Court of Appeal?
Because, my lords, that's the only way in which it can only be interpreted. The Criminal Appeal Act, if I may just refer to it, is the interpretation section that you so rightly refer to, says appeal means an appeal by a person convicted upon indictment. And this is an appeal in relation to an appeal from the High Court or from the Assizes. What we're dealing with now, my lords, is where we have gone beyond that, where a person has been dealt with by the Court of Appeal, and where the issue is, do we have any further recourse in the pyramid of a hierarchy of courts? And this is correct, in that this is only referring to appeals when you're convicted from the Assizes. And that's my submission on that with respect.
However, Mr. Leacock, if that were the case, I think that Section 2.1 in defining appeal would be restricted to Part 1 of the Act, which deals with criminal appeal from the High Court. It's not so restricted, so on the face of it, it would appear to cover both Part 1, appeals from the High Court, and Part 2, appeals to the Privy Council.
If that were correct, with the greatest respect, my lords, then Section 37 would be an extremely restrictive and limited section, and there's nothing on the face of it which suggests that when you're outside the Court of Appeal, or when if you wish to go beyond the Court of Appeal, that can be correct. Because one has to contextualize this in relation to not only what the Act says, but what the other legislation had allowed us to do at the time. And that refers also to the prerogative powers which we already had, as well as the fact that I will give you in a moment, if it's necessary, other appeals where the Crown has appealed in other cases on the similar legislation, not necessarily from Barbados, but from other jurisdictions.
Appeals to which body?
To the Privy Council. One of the most recent cases is the case of
But in those cases, doesn't the Privy Council indicate that it has a discretion to hear appeals, which discretion arises out of a prerogative power that is vested in the Privy Council itself?
Yes. The answer to your question is yes. If you
So that, just now, if that is the case, then how can the Crown as an appellant take advantage of that right? If it is a right that is vested in the Crown as judicial committee, as distinct from the Crown as appellant, how can the Crown as appellant before the CCJ seek to take advantage of that right?
my understanding of of appeals to the Privy Council, my lords, when we had that right, was that if you had a right to appeal, it was always subject to the leave of the Privy Council.
Just a minute. You speak about a right to appeal. There are two things here. There's a right to hear an appeal and a right to appeal.
Indeed, my lord.
Now, the cases that you, I believe, are alluding to deal with a right to hear an appeal.
But beyond that, if I may just draw to your attention some dicta in a very recent case. I think
we can give special leave to appeal under Section 8.
Yes?
from a very recent case, from it arose from Trinidad, it went to the Privy Council. It's the last case in my bundle, Brad Boy's case. There's dicta in that case, which in my respectful submission answers your lordship's question. Brad Boyce was an appeal under a statutory section, but there is instructive dicta I found with paragraph 15 of that decision. It's the very last case in my bundle with respect, my lords. And this is where counsel Mr. Hudson Phillips argued that the common law had immunized appeals certain rules as a common law. And if you just permit me to read...
Could I ask what paragraph did you say?
Paragraph 15 of the Brad Boyce case. It's the very last case in the bundle. It says, if I may read this, it is therefore not sufficient that the law at the time of the Constitution gave one a right to be immune from further proceedings after an acquittal by a jury. Section 4 entrenched only fundamental human rights and freedoms, and the question is therefore whether the old common law rule, which prevented the prosecution from appealing against an acquittal, formed part of the due process in this narrow sense as a fundamental right or freedom. Their lordships do not think that it did. They would accept that the broad principle that a person who has been finally convicted or acquitted in proceedings which have run their course should not be liable to be tried again for the same offense is a fundamental principle of fairness. It is recognized as such in many constitutions. See, for example, sections 20 of the Constitution of Jamaica and in the International Human Rights Instruments and the listed Article 17 of the UN Convention on Civil and Political Rights, Article 4 of the Protocol of the European Convention on Human Rights and Fundamental Freedoms. But they do not think that the principle is entirely without exception. See, for example, Article 4.2 of the Protocol number 7. And they certainly do not think that it is infringed by the prosecution having the right to appeal against an acquittal. The possibility of such an appeal is accommodated in the qualification of principle. This is the point I wish to make. Save upon the order of a superior court made in the course of appeal proceedings relating to the conviction or acquittal. In all the Caribbean constitutions to which their lordships were referred, Jamaica, Barbados, the Bahamas, etc., as well as in the international instruments which their lordships have mentioned. My lord, this, in my respective submission, is a recent decision, and this dicta, in my submission, is instructive in answering your question. Inasmuch as this was an appeal from a directed acquittal, the Privy Council went on to provide this dicta, which, in my view, answers your lordship's question.
Yes, go ahead.
If I may proceed, then,
But,
Mr. President.
The provisions that apply to appeals to the Privy Council may provide some assistance in interpreting those that have now govern appeals to this court. But really, what is important, I would have thought, is the provision that governs the appeal to this court, which of course is in the CCJ Act.
Right.
And I don't know that the definition of appeal in the Criminal Appeals Act would govern the construction of Section 6 of the CCJ Act.
My lord, if I may say, I could not have put it better myself. And therefore, it is my submission that if I may return to answer you specifically, Mr. President, as to your question to me as to addressing you on the question of the interpretation of whether this is a matter of interpretation or application.
Well, I think you see, going before we leave the other point, I mean, this is what strikes me as important from the previous learning on appeals by the prosecution to the Privy Council. And I think that the authorities which you have referred us to about the right of the Privy Council to entertain appeals from the prosecution indicate that there is no rule of common law which precludes appeals reaching the final court, being brought to the final court from the intermediate court by the prosecution.
Indeed, my lord. I think that would have been my conclusion if I'd argued right through. But if you've taken us to that point, I would be quite happy to take it to go from there, my lord.
But that's only how it appears to me at the moment. But I do feel that whatever view one takes of the right of the prosecution to appeal under Section 6C, and I have indicated how it appears to be provisionally, but whether that provisional view is correct or not, I think I know I speak on behalf of my colleagues. I think that the real hard nut you have to crack is to bring this within the term interpretation of the Constitution. So perhaps you might proceed to deal with that.
I'll be guided accordingly, my lord. Is this a question of interpretation of the Constitution within Section 60? My answer is yes, for the following reasons. One, at paragraph 29 of the judgment of the Court of Appeal, the Court of Appeal itself expressly said it was interpreting the Constitution. Two, the Court of Appeal interpreted the Constitution to require the Fair Hearing Clause to embrace or to encapsulate an in-camera hearing by a judge for an application of reclusal. My lords, with the greatest respect, the fair hearing provision is a very wide provision, almost as wide as the President's foot. The question is, where are the limits? The Court of Appeal has said in the instant case that it has interpreted the Constitution, and in paragraph 10, this is not my words, it's their words.
Mr. Leacock, do you think that's a misnomer?
No, with the greatest respect, Madam Justice.
Because it seems to me to be an application of the fair principle, fair hearing principle, rather than, because they called it an interpretation.
No.
Doesn't necessarily mean you
My lord, my lady, with the greatest respect, we cannot honestly say that. The Court of Appeal expressly said they have interpreted the Constitution. And let us look at what they've done.
Are we bound by what they say?
With the greatest respect, you should be guided as to their state of mind by what they've said.
Well, you know, if they say that it's within the interpretation of the Constitution, you say that makes it a question of interpretation. I'm not even sure that they are saying that it is a question of interpretation. They are saying that they regard it as unfairness, and unfairness falls within that provision of the Constitution. It's unfairness in the sense of an absence of the fairness which that provision requires.
Now look, if you would just give me a little attitude on this one. The Court of Appeal, the only way they could have come to that conclusion was to have, in my submission, was to have interpreted the fair hearing provision. Because how else are you going to say that a reclusal application is in breach of the fair hearing provision without saying what is the meaning of the fair hearing provision or interpreting the fair hearing provision to require that that is an indivisible component of it?
But the other point, Mr. Leacock, isn't really important whether or not in every case, the application, or in any case for that matter, an application to recuse should be heard in chambers or in open court. I think for what it is worth, what the Court of Appeal acted on was the prejudice which they said flowed from the statements made in the presence of the jurors in waiting. Now, you know, whether that could have been avoided without having a hearing in chambers by simply having them removed from the court.
Mr. President, with the greatest respect, that might be one way of looking at it. But we have to look at the reality of what actually happened. The question, therefore, that follows is, could a court, a judge, on his own motion, decide to exclude the public from a hearing without an application or a request? He might be able to do it. But the question
Not
is,
the public. Not the public. Those members of the public who were in court because they had been summoned to attend for jury service.
Well, if that were so, then what would stop those who remain in the court from discussing what happened in court with the jurors who were excluded?
Well, you could not you could rule that out, but it seemed that when you say those who remained in court, you mean the members of the public?
Indeed, my lord. Taking your example as a hypothesis.
There are various things in that what's perceived to be a real nature. then the case could have been put for the next day and the jury sent away and told not to return until 2 days' time. But you know, it's a little far-fetched to think that they're going to, the members of the public are going to, you know, make a point to report to the jurors in waiting what happened. When there is a voir dire in the course of a trial, the jury is put out. Not so?
In the course of a voir dire.
A voir dire.
Yes. Yes.
The jury are put out of court,
Indeed, my lord.
but the public remain.
That's correct, my lord.
Yes.
That brings me therefore to my next point.
And that the jury, you know, may not be sequestered. But go on anyway.
Thank you, my
But
lord.
what the point I am seeking to make to you is that the device, if you like, which the Court of Appeal identified was not that it wasn't held in chambers, but that it was held in the presence of the jurors waiting.
Thank you, my lord. If that were as that is the case, the next question is it therefore every vice that must be that will lead to prejudice that will cause a conviction to be quashed? My submission is there must be a threshold of materiality, and what happened here does not come anywhere close to any threshold of materiality to warrant the drastic action taken by the Court of Appeal in this case. When, in the context of what happened, there was no application for this matter to be heard in chambers. Two, this matter was never drawn to the attention of the trial judge, but was taken firstly at the level of the Court of Appeal as a new semantic ground. And the Court of Appeal chose to act on it without having it substantiated. That is the real vice here.
That goes to the merits of the.
Indeed, but one can hardly get to the merits without one has to get to the merits to refer to the factual basis of it, and therefore my submission on this matter, Your Honours, is that one, the Court of Appeal expressly said they interpreted it. Two, the Constitution. Two, they interpreted the Constitution to require that the applications should have been heard in the absence of the jurors when no application was made to the trial judge for that. And thirdly, this prejudice, if ever there is prejudice, and I'm not conceding for one moment that there was prejudice with respect, but this so-called prejudice does not come anywhere close to the materiality threshold that would be needed to warrant a quashing of the conviction in the circumstances of this case.
But isn't that the real issue which the Court of Appeal had to decide? That is whether what was said in the presence of the jurors in waiting really was really reasonably capable of creating the sort of prejudice that would justify overturning the conviction. Isn't that the real issue?
That is what the Court of Appeal said.
No. That's what I'm asking you. Isn't that the real issue which the Court of Appeal had to decide?
No, with great respect. What the Court of Appeal...
But if it were, that would not be a question of interpreting the Constitution, would it?
My Lord, what the Court of Appeal did is to convert a simple application, a simple ground of appeal into a constitutional issue. That is the nub of this matter.
The nub of the matter, Mr. Leacock, is whether they can actually do that. Because I think what we have to concern ourselves with at this level is we don't want to get involved with all the nitty-gritty of 100 or 200 things that might go wrong in the course of a trial and might be alleged to prevent there being a fair hearing. Surely we have to look at a fair hearing and only at the general attributes of what a fair hearing is, and then you apply the general attributes to all the nitty-gritty facts. And could one not say in this case that the basic general attribute of a fair hearing relevant to the particular circumstances of this case is there's just a need to be seen to be tried by an impartial, unprejudiced jury and judge? That's the basic attribute of a fair hearing that's relevant here. Then there are all sorts of nitty-gritty points that could enable someone to argue that the accused wasn't seen to be tried by an impartial, unprejudiced jury and judge. And we're happy to leave those nitty-gritty things to the Court of Appeal to sort out without there being any appeal as of right. Although in very special circumstances, of course, there may be an occasion for a discretionary grant of leave.
I perfectly understand that. And if that was the course taken by the Court of Appeal, that would have been fine. But they didn't. They converted an application into a constitutional issue and purported to, and then interpreted the Constitution, Section 18 of the Constitution, which really has now worked havoc. Because if this, one of the real issues there is that this has now created quite a floodgate. That somebody simply now just has to stand up and say, I don't want Judge Brown to try my case. One day they might stand up and say, I don't want the Director of Public Prosecutions to come to prosecute me. And what do? Do we then, in the face of that, without any materiality threshold, without any evidence whatsoever, say, oh, that's prejudice, and therefore we must grant a new trial?
But
That would
surely
be the issue.
the ground of appeal that was that the judge should have recused itself was abandoned. It was not argued in the Court of Appeal that the judge was wrong and not to recuse itself. So what you are saying, the mischief that would flow from this decision can't be what you said. The Court of Appeal never held that the judge should have recused himself.
Indeed. What the Court of Appeal confined itself to in its decision was the fact that the application for the recusal was made in the presence of everybody.
No. What the Court of Appeal held was that what was said about which suggested that the judge was that the accused was forum shopping meant that he was guilty. And the fact that what you said about his having been legally aided meant that he should be regarded less favorably than someone who was paying his own or her own lawyer. That's what they said. That's what the basis of their decision is. And that I'm not suggesting anything as to the firmness of that basis. But that is what they held.
Okay.
I mean, that is why they said the trial wasn't fair.
Very well, my lord. If we take those two propositions of you, as you have so eloquently put them, namely that what the prosecution said, the man was on legal aid, full stop, and that could have caused prejudice according to the Court of Appeal. And secondly, that in light of that, my lord, doesn't that in itself raise the most preposterous conclusion by the Court of Appeal? It does.
You see, before you get to whether it's preposterous or not, you have to show that you have an appeal as of right.
Indeed, my lord.
And that this is this preposterous conclusion somehow involved an interpretation of the Constitution as opposed to the exercise of the drawing of an inference from what was said.
Indeed, my lord. And I'm delighted to answer your lordship on that. In saying that, if I start from the beginning again, if we will have to look at what the Court of Appeal actually said in order to answer you. And we can only do that from their decision, my lord. And with the greatest respect, I cannot say that when the Court of Appeal said they interpreted that they were misspeaking. This is our highest court at that level. And we cannot assume errors of that nature to them in giving decisions in a capital matter in which they are purporting to interpret the Constitution. So I cannot accept that as a tenable proposition. So when they said in the paragraph 29 on disposal that they have interpreted it, the Court of Appeal actually converted those very points that the learned president made so eloquently about what the Constitution has said and about what it said about forum shopping. The issue as to whether or not that violated the fair hearing provision of the Constitution. And the only way they could have concluded that it was in violation of the fair hearing provision was to have interpreted the fair hearing provision. And they interpreted it with the conclusion that it required an in-camera hearing. And on that basis, we're saying they were erroneous. One, and secondly, they expressly said, and we should not look beyond that. They expressly said in paragraph 29 that they were interpreting the Constitution, and therefore this court is bound, in my respectful submission, to accept this decision of the Court of Appeal as they said it, that they interpreted the Constitution, and we cannot go lifting the veil to see what they meant, whether they misspoke or not. That is what is written here. They interpreted in accordance with the Constitution. If they had said they interpreted it, I might have gone along with Madam Justice to say, but perhaps they misspoke. But they said they interpreted in accordance with the Constitution. That is express language that goes to the kernel of the matter. And in my respectful submission, we cannot look behind the veil.
But does that bind this court? I mean, the fact that
Maybe
they
I put
said,
it too highly.
they said, look, we are interpreting the Constitution, and does that form a basis for a right of appeal? Let us suppose that they are wrong about.
But that is why I'm here, because they are wrong about it. Because what they have done, they have interpreted it, they said they were interpreting it, and we cannot go back and say, oh, they're not really interpreting it, they're applying it. In most decisions, these words are not even used. But here, it's like the words of the statute. It's expressly stated, I am interpreting it. We must assume that they...
But Mr. Leacock, quite apart from the Constitution, a person on trial has, as an inherent and essential feature of the criminal justice system, a right to a fair hearing. Doesn't he?
Indeed, the law, that's guaranteed by Section 18 of the Constitution.
So that quite apart from anything that's in the Constitution, the Court of Appeal was entitled to make a determination as to whether, as part of the criminal justice system, this appellant had had a fair hearing. Never mind in what clothes they dressed it up in. As part of the criminal justice system, they were entitled to make a determination as to whether the person had had a fair hearing.
Indeed.
And they made that determination. You say wrongly, but they made that determination.
The only difference that I would express with the greatest respect to you, sir, is that they made that determination in accordance with the Constitution. If they had said they made that determination in accordance with the rules of fairness or procedural fairness, then I wouldn't have a leg to stand on, because
the rules of fairness that you're referring to, would those rules be different from the rules in the Constitution?
Not substantially at all, because the Constitution incorporates the rules as of the date of enactment. So it doesn't. But when they have actually gone on to say they've done it in accordance with the Constitution, that is what gives me the right to appeal, because they are purporting to act on the Constitution which, if they had said they were acting in accordance with the rules of procedural fairness, which we all could accept, that would not give me a right necessarily an appeal as of right. But I have a right of appeal, and I have the right to appeal on this matter because they have acted in accordance with the Constitution, and in my respectful conclusion, erroneously.
They acted in accordance with reference to the protection given to an accused person under the Constitution. The right to a fair hearing. I don't know whether I regard that as an interpretation of the Constitution.
So if that would be correct, madam, it would be that you are disregarding what the judgment says.
I know what the judgment says. I'm just seeking to put a different. I don't regard it as being an interpretation of the Constitution. They acted in reference to the Constitution and also applying Section 18 of the Constitution to the facts. If the decision can be called it is that they did not tell us what was the cumulative effect of the other matters raised in the appeal.
Indeed.
You know,
So
you know,
that's
Miss,
the difficulty, right?
I don't know that there is really any scope for interpreting the two simple English words. Fair hearing. I think everyone is agreed that a hearing is not fair. If things are said in front of the jury outside of the evidence, which prejudice them against the accused. So there's no dispute as to what fair hearing means in this context. What is the issue really is whether what was said had that effect or could reasonably be expected to have had that effect. That is not a question of interpreting fair hearing, is it? And whatever the Court of Appeal may say, can't change that. Would you agree?
In a qualified sense, in that, you see, my submission is that if you say, as they have said here, that it was in breach of the fair hearing provision of the Constitution, you must have had some parameters as to what is fair hearing. And their conclusion is that the fair hearing provision is breached because of the forum shopping point and the point about legal aid. Now, the issue is, in order to say that the fair hearing provision has been breached, you have to say that these two things, have fallen outside of those parameters. In saying that these things have fallen outside of those parameters, you are interpreting the fair hearing provision as saying that these things are not included.
On the particular facts.
It could only
So that they might or might not be.
be on whatever facts you're dealing with.
So that really, it's not a matter of interpreting what fair hearing is. It's whether, in the context of this case, whether they did in fact receive a fair hearing.
Indeed.
And that is not an interpretation of fair hearing in the Constitution.
But even on that point, we can say that the Court of Appeal again would have erred, because what was raised here could not have caused an unfair hearing. These 2 points. I mean, in the whole scheme of a criminal trial, where we're discussing where a man shoots another man in his back, I can't get into the evidence, but there's a self-written statement by the man, written in his own handwriting for 5 pages. These are the things we will determine whether it's a fair hearing, not whether a judge says, you're playing ping pong with this court. Judges are entitled to make strong statements, and this court is not averse to even doing that. And if a judge were to say that you're playing ping pong with this court, or the Constitution says...
What does that mean?
Ping pong?
Well, I know what ping pong is.
Well, I think it is
What
meant.
does playing ping pong with the court mean? Are we playing ping pong with you? I don't know what it means.
Exactly.
You can tell me.
Exactly. And that is the point, Mr. President. That is the point. This does not satisfy the materiality threshold to say that there was any breach or that there was any prejudice to warrant the drastic action they have taken in quashing the conviction. That is the kernel of the matter. Did this man get a fair trial? Was the trial unfair because, let's assume the judge had said that, because let's also remember, it was disputed before the Court of Appeal whether that was actually said. And if I ever get to the merits of this case one day, I will deal with those things.
I think it would be on stronger ground speaking for myself.
But suffice it to say, that in coming to the conclusion of quashing the conviction on the basis that the trial was unfair, it was the scales were really not even or anywhere near even. It was just erroneous what the Court of Appeal did in this case. In coming to the conclusion that even if you agree that the judge said that the appellant, the respondent is playing ping pong, and even if the jury hears that the man has fired several lawyers which came from his own side, all the prosecution said he was on legal aid. To say somebody is on legal aid is not a crime. And for the Court of Appeal to come to the conclusion that that could have prejudiced a criminal trial where a jury, after deliberation and consultated on the matter, came to the firm and unswerving conclusion of a unanimous verdict, to quash it on that basis is outrageous.
But would you agree with me that this case is not distinguishable from Pereira, except on the basis that the Court of Appeal made some reference, or the reference you have identified, to the interpretation of the Constitution. But apart from that, this case is not distinguishable from Pereiraism.
Indeed, my lord. I cited Pereira principally to show you my legal right. But as you said, you prefer to hear me on whether it was an interpretation. So if I have understood you correctly, I think we can agree that the Crown does have a right to appeal. The question is whether that appeal falls within 6C, whether it falls within an interpretation.
I don't know about agree,
Well, that would be my submission with great respect, my lord,
Yes.
that the Crown has a right to appeal. Because there is even, now that you've said that, I was about to refer you to another very recent case in which the Crown had this right to appeal. The case from Trinidad, I didn't have a photocopy, but I have the name, in which very recently the DPP of Trinidad, in an appeal, cross appeal, and the Privy Council referred to it as the cross appeal, albeit they dismissed it. But the fact of the matter is that they recognized that the DPP had a right of appeal.
But, Mr. Leacock, isn't that because statute expressly gives him the right of appeal, as appears in paragraph 8 of the State and Boyce judgment?
No, that was not. No, my lord. With great respect, that was not in that context. Thank you very much.
Mr. Leacock, what I'm suggesting is, in a sense, you deal with the respondent's case. I think what they're suggesting is that unless it's under the prerogative power, which they argue no longer exists in Barbados, you need the Crown's power to appeal to be set out expressly rather than by implication, and that there's no express setting out, as there is in many other jurisdictions.
My submission to that, with great respect, is that it is expressly set out. It's set out in section 6 of the of the CCJ Act of Barbados. And that, in my submission, gives us an express statutory provision in addition to the prerogative powers which we had, and in addition to the old power we had under Section 64, which has been repealed and replaced also. So we do have a statutory position in Section 6C of the 2003 Act, and we do have the prerogative power under the Pereira case, if you were to accept that. And the one I was about to refer you to is not a specific statutory provision. This is the one in Trinidad. The case is Krishna Prasad and Ram Singh Jairam against the state. I think the learned president should be familiar with it, but I don't have a photocopy. But the point I wish to make.
But
What's the case?
Ram Singh Jairam.
Krishna Prasad and Ram Singh Jairam, 2001 UK Privy Council. And the point I wish to make is that this was an appeal with by these two persons. And at paragraph, the Privy Council referred to the cross appeal of the Director for the Prosecutions in Trinidad. Paragraph, whatever that is. It says there 9, the state now contends in its cross appeal that in treating the appeal in this way which has been described, the Court of Appeal exercised its statutory jurisdiction.
Exceeded, yes. The Court of Appeal exceeded this.
Exceeded, sorry, thank you. That it did not expressly find that there had been a misjudgment. It simply remitted the case back, as it said in limine, without any full consideration. The lordships are not persuaded that there is here any excessive jurisdiction. The members of the court have all formed a view, and they get into the merits of the case here as to why that. But suffice it merely to say.
Is it in there?
Suffice it merely to say, my lords, I've cited this in answer to your lordship, and that here it is the DPP had actually cross-appealed, which is an expression and exercise of his power, and this was not under the statutory Administration of Justice Act in this country.
No, but that power was based on the powers which the Privy Council retains under the Judicial Committee Act. That is the basis of that. It has nothing. Yes, that has nothing to do with statutory, local statutory provision.
Likewise,
it's rather like the inherent prerogative referred to in Pereira.
My understanding was that this would have fallen like us under our Section 64 of the Supreme Court of Judicature Act, which had given us the right to appeal in criminal or civil cases, which has been repealed and replaced by 6C. And that is why I've cited this, because this is exactly in pari material what we also had until we had the CCJ as our final court.
Yeah, so I think in the case of most territories with appeal to the Privy Council, the Crown could appeal from the Court of Appeal, either under an inherent prerogative power or under the provisions of the Imperial Judicial Committee Act.
Okay.
So I mean, none of that applies to Barbados today, does it?
Yeah.
But we have to look at what we have now based on what we had, because what we have now was not intended to derogate from what we always had. That's the point I'm making with respect, my lord. So if we had this, and our legislation that established the CCJ as the final court simply gives us back what we had, but in a different form.
Why don't you go back to the Constitution? Go back to the Constitution and see what they say in Section 88. What does it say in Section 88 of the Constitution? Parliament may provide for an appeal to lie from A, decisions of the Court of Appeal established by Part 1 of this chapter to the Caribbean Court of Justice, either as of right or with leave. And then subsection 2 says, nothing in this Constitution shall affect any right of the Caribbean Court of Justice to grant special leave to appeal from decisions such as are referred to in subsection 1. That is the one dealing with appeal decisions of the Court of Appeal.
Well, thank you very much, my lord.
So, I mean, shouldn't we start there?
But I think after hearing me, I think we've gone past that now, in that I think if I, unless I've wrongly understood it, I think if we of all can accept that the Crown has a right of appeal. And the question is whether or not we would fall within the statutory provision which we have, which the President has been asking me to address on whether it is an interpretation of the Constitution.
Yes, would you like to move on?
Indeed.
I don't know if you have any other.
If I may just address that narrow issue
What narrow issue?
as to whether we fall within interpretation,
Whether?
whether it's a matter of interpretation or application of the Constitution.
Yes. All right.
Look, on this point, I adopt my submissions in total from paragraph 37 of my response, and I will seek to flesh them out. I cannot help but starting at the beginning where I started, that the actual decision itself says it was an interpretation. And secondly, that this is a matter of interpretation because it was found to be in breach of a fair hearing of the Constitution. And the only way it could have been found to be in breach of the fair hearing by the Court of Appeal is because they interpreted it. I cannot put it more bluntly than that. And in misinterpreting the fair hearing provision, the Court of Appeal concluded that the forum shopping point and the legal aid point, which they found to be of matters of great moment, violated the fair hearing provision. It is my submission that those 2 points cannot violate the fair hearing provision of the Constitution. One, because no application was made for exclusion of the jurors, and 2, the so-called prejudice that the Court of Appeal found does not constitute prejudice, A, or B. It does not satisfy the materiality threshold of prejudice to warrant a quashing of the conviction on the basis that the trial was unfair. My Lord, I have referred you to a number of cases, Joseph, and I will not. I will take them as having been read, because those cases, in my submission, Joseph, Freighter, the contempt case from Jamaica, and Harry Kasoon, the school teacher's case from Trinidad, were all cases in which no interpretation of the Constitution was needed. In fact, in the respondent's bundle, he refers to an Indian case which defines interpretation as meaning where there are 2 or more meanings. I have no quarrel with that case. I have defined it in the context of parameters. Here, the Court of Appeal has come to the conclusion that the parameters of what was said by the judge Ping Pong and what was said by the prosecution that the respondent was on legal aid was a violation was a breach of the fair hearing clause.
Mr. Leacock, the very first sentence in the head notes, the very first sentence in the head note of Joseph and the state of Dominica. The question whether a case has received a fair hearing within the meaning of Section 8.1 of the Constitution of the Commonwealth of Dominica is not a question of interpretation, but a question of the application of those words to the facts of a particular case, why isn't what is said there relevant to this circumstance?
Because it has to be contextualized, my lord, on the facts that you have before you. For example, in Joseph's case, they were seeking to re-argue grounds that were already argued by the Court of Appeal. Suppose it were different. Suppose the facts were that they wanted to call an expert DNA witness to say that any blood samples found on the body was not taken from the man. That would require an interpretation of what is a fair hearing in a different context. And in my view, that is what is an interpretation. What the fair hearing as dealt with there is an abstract concept without a factual basis. And in Joseph's case, they were seeking to re-argue things that were already rejected.
So dependent on the factual matrix,
Indeed.
fair hearing could require interpretation or it could require application. Is that what you're saying?
Indeed, my lord. That is what I am submitting. As for example, in the Freitas case, Freitas was convicted of contempt, and he was seeking to argue as of right, and the Privy Council said this did not require anything to do with fair hearing, as well as the Harry Kassoon case from Trinidad, in which he got a letter purporting to dismiss him, and they said that he didn't get the letter in time and whatever, and that he was entitled to constitutional redress. And the Privy Council said, in doing that, you are seeking to debase the provision because doesn't require any interpretation, and the court must be vigilant to allow that kind of.
You know of
thing
any
as a-
cases where fair hearing was held to be a question of interpretation?
In fairness, I have cited cases where it was not. As to whether I can tell you one off the top of my head, I don't think I can tell you. I can't tell you that off the top of my
What
head.
is it about the issue of whether a statement was prejudicial that makes the question of a fair hearing one of interpretation? Why is that? Why is that actual matrix so different from Joseph or Freitas or any of the other cases you're referring to that makes it uniquely fair? An issue of interpretation of the Constitution.
That's an excellent question, my lord. And the answer lies in the fact that the Court of Appeal is the ones who made it a constitutional issue when it was not. And since they have made it a constitutional issue, that is why we are here.
Yes. I understand.
It's the Court of Appeal that has converted a simple, straightforward matter into a grave constitutional matter of great import. And it was the only basis by which they could have quashed the conviction. Because if they had gone outside of the Constitution, they would have found it extremely difficult to come to the conclusion they've come to, especially since they never, on this decision, analyzed the other grounds of appeal. They just blandly said, and for other whatever reasons or other grounds, it's that their conversion of it into a constitutional point allow them the latitude to quash the conviction. And in doing that, they brought themselves within Section 6C.
But they could also quash the conviction merely by applying the meaning of fair hearing, couldn't they?
They could have, but they didn't.
Well, it's a question of how you characterize what they did and whether their characterization is correct. Because the trouble with interpreted, a layman can use interpreted in a very broad fashion. And occasionally even judges use words in a very broad fashion without thinking through to a technical meaning.
I would accept that proposition if you're giving a public lecture or something, not when you're writing a decision in a capital case, all three members of the court. I cannot accept the characterization that they didn't know what they were saying. I really cannot accept that with the
Yes. All right, I think we've got the observation, Mr. Leacock, on that.
Indeed, my lord. So, if I may, if you're satisfied, if there's nothing else specifically you wish to ask me on the interpretation point, there's just one other point I wish to make before I wrap up, my lords, unless you wish to ask me anything else. I just wish to submit that on the other basis, namely a literal interpretation, which the court is entitled to take, of section 60, the conclusion is incontestable that there is a right of appeal of the prosecution on the interpretation of the Constitution in this case, because the words are clear and unambiguous, and they're only susceptible to one meaning, that both parties, the Crown and the appellant, have the right to appeal, and have cited dicta from the case Grant and the DPP. And I would invite this honorable court to conclude that the appeal should be allowed for the reasons which I have set out in my written submissions to laws. And
Well, we are not at that stage now, Mr. Leacock.
indeed,
Just one question I wanted to ask Mr. Leacock. All the other grounds were argued before the Court of Appeal?
there were about 8 grounds that were argued before the Court
All
of Appeal.
argued.
They were all argued. Indeed, my lady. But they only refer to one ground in the decision. And it's my submission that that in bringing this matter, the forum shopping point and the legal aid point under the Constitution, that is what provides the interpretation as against a mere application. And it is really an interpretation of the Constitution which the Court of Appeal purport to do in order to come to the conclusion they've come to. And that is the interpretation which we wish to have corrected by this honorable court.
Might I posit the view that the ping pong may be related to the forum shopping?
I think so, assuming that the judge had said it, because I wasn't there, so I can't tell you he said it. But it was alleged that he said it, and there was dispute in the Court of Appeal as to whether or not he'd actually said it or what was published in the newspapers. But the Court of Appeal acted on what they said was in the newspapers, and those are points that were referred to the merits of the case. But the ping pong, yes, I would think refers to the fact that he was moving from judge to judge in the hope of getting a favorable judge, perhaps, or something like that. And it is.
Are you are resting your case on section 6C,
Indeed.
and that is it.
I'm resting my case, yeah, that
So
that is clear.
If we were to hold that this was not a question of interpretation, that would be an end of the matter. Is that so?
Yes, I'll be frank with you. If you were to find that it is not a question of interpretation, I would concede that under Section 6C, I will not have a right of appeal because I do not come within 6C.
Yeah.
But on the broader issue, even if you were to hold that, I would appreciate it if you would indicate whether or not I do have a right of appeal, either under that or no. In doing that, you would have held that I have a right of appeal, but I just do not qualify under 6C.
Well,
I want also to establish that I do have a right of appeal, for the simple reason that these matters have not been taken up before. And my submission is that it's not because they have never been done. Before I became director, no other director had ever filed references, for example. I filed references to quash convictions that were 20 years old. It doesn't mean that because it was never done that we never had the right to do it. But I do it. So I would wish to reiterate whether or not, however you rule on this, that I do have a right to appeal. So whether I have a right in this case or for the future, I do have a right to appeal.
In your written submissions, you said alternatively, if the court is not satisfied, the Crown has a right of appeal. In this case, the court should treat this matter as an application for leave to appeal, pursuant to Section 8 of the CCJ Act. Is that what you still want us to do, or you drop that?
No, I'm not necessarily dropping it, but from the discussions and from the pointed questions put to me by the president, I am satisfied in my mind that I do have a right of appeal, and that I really do not need leave in this case.
But if
That might be appropriate for another case.
But if we would rule, because that is what you said, if we would rule that you do not have a right, do you want us to consider this as an application for leave, special leave?
When I wrote that, yes, I wanted you to consider it if I did not have a right. But
You what?
I think
Sorry?
Yeah,
Can you
I'd like-
repeat that? I didn't hear.
Yeah, the question is whether I'm still relying on the application for special leave. But I'm saying after the forensic, after the questions from the court, I am satisfied in my mind that I think I do have a right, although I would like to see it in writing somewhere. But I will not insist on that.
I don't know about insisting, but can I take it that you are not pursuing any application for leave under Section 8?
Yes. Okay. Yes, I will not pursue the application.
Yes, I'm much obliged, Mr. Leacock.
Thank you very much. Unless there's any other matters you would like to hear me specifically on, my lord.
Yes, thank you.
Thank you very much.
We want to, I think we're going to, whether we agreed on it. I mean, we are going to take a short break now. We'll return at 11:45.
All right. All right, President and judges of the Superior Court of Justice.
Yes. Mr. Hines, like to address us now? I'm not sure which council is going to address. Perhaps I can indicate that what we would like to hear you on is the question of whether the prosecution can have a right of appeal or does have a right of appeal under Section 6C of the CCJ Act. And then we would also need to hear you on with regard to what has been termed the cross appeal. That is to say, not on the substance of it, but on whether that can be pursued or not, or whether you would require our leave to pursue it, and if so, whether that leave should be given. Yes, you may proceed.
Here, please, Your Honors, the appellant has attempted to mount this basis of Section 6C of the Caribbean Court of Justice Act. And our position, in terms of the respondent, is quite simply that we start with the statement that there is no statutory basis for that alleged right. If it is alleged to be in the Section 6C of the Caribbean Court of Justice Act, our contention briefly is that the mention of the word appeal in that act does not include the appellant.
Does
not include the appellant.
The word appeal?
I am referring, Your Honors, to Section 6C. In any civil or criminal proceeding, an appeal shall lie to the court. I'm referring to the second word, appeal shall lie to the court on decision of the Court of Appeal. We're saying that that appeal does not include an appeal by the appellant. That's the substance of submission.
By the Crown? Or by the whom?
When I say the appellant, I mean the Crown.
By the Crown, okay.
Thank you very much. It does not include the Crown. Our contention is that that covers usually the accused person or the convicted person. It does not include an appeal by the Crown. My learned friend has attempted to link that section with Section 64 of the Supreme Court of Judicature Act. And
Yeah, but now, before you get there, why do you say that the word appeal in the CCJ Act means an appeal only by a convicted person?
at least I'm saying, sir, that it does not include the Crown because of the history of appeals. The history of appeals suggests that the any appeal by the Crown should be specifically or contextually indicated in the particular act, because the Crown has
You mean an
never
appeal from a
appealed
court
from
of
the Court
appeal
to the
to the
ultimate
final court
tribunal.
is always expressly given.
Precisely.
There was never any prerogative.
Unless it's prerogative situation.
Yes.
I don't think there's any issue about the prerogative or the former prerogative, because in our submission that prerogative no longer exists.
Yeah, but in the case of the Judicial Committee Acts, those were not local Barbadian acts, were they?
They were not.
So that the right of appeal came before the local acts, isn't that right? So that you can see that there can be an appeal from the Court of Appeal to the final court by an act which operates outside the local jurisdiction.
We can see that, sir.
So that if the agreement establishing the CCJ Act, CCJ, contained that provision permitted an appeal by the Crown, then if you locally incorporated that in Barbados, that would give effect. That would make a change in what you say was the position before the CCJ Act, wouldn't it?
I would say, I would agree with you, sir, if you were saying that the prerogative, in inverted commas, that facility has in fact been transferred.
Could you speak a little louder, Mr. Hines?
I would agree with you if you were saying that that prerogative was transferred to the CCJ. But our position is that that prerogative has been cancelled, discontinued, repealed. It no longer exists, and it applies to it applied in its day to the Privy Council. When we are looking at Section 6C, we have to ask the question, in terms of Section 6C, does this include an appeal by the Crown? And we are saying that the section does not include an appeal by the Crown because it does not specifically say so.
But there is nothing in the section to suggest that limitation is
The limitation, sir, is the limitation arises from the fact that it is a matter which concerns the liberty of the subject, and that is the reason why we are saying that it does not include the Crown. I have said in
You mean a matter concerning the interpretation of the Constitution is necessarily a matter concerning the liberty of the subject?
So the history of this matter is that the Crown has never really, putting aside the prerogative point, the Crown has never had a right to appeal to the Privy Council.
no.
Except that facility is coming from the Privy Council in terms of the Judicial Committee Act.
But what if the right comes from the CCJ agreement as adopted municipally by Barbados and the other contracting states?
Well, if that right can be found in that arrangement, sir, I would have no difficulty in conceding that.
In other words, if you start with the CCJ agreement or the CCJ Act, is there anything in the history of that agreement which suggests that that right should be cut down to cover only appeals by convicted persons? You agree that there's nothing on the face of the Act that says that it is limited to to a convicted person?
I'm saying, sir, that it is because of the fact that the Crown has never had this facility.
Yeah, but assuming that is so, Mr. Hines, this act derives from the CCJ agreement. And your history of what the Crown did and did not do, does that really help you very much with the interpretation?
But I really cannot, I cannot take a position on that because I have not looked at it in that detail. I look at it from the point of view of the act, the particular words of the act, which follows to some extent Section 64, and which substantially is in agreement with the Section 37 of the Criminal Appeal Act. And that is where in my humble submission, the difficulty arises. If there is some accommodation from the agreement, I would have no difficulty in conceding that that exists.
Yeah, so what I'm saying is that the CCJ Act is merely a municipal adoption of the CCJ agreement, the agreement establishing the CCJ. And unless you find that there was a particular history relating to that agreement, which suggested that Travel 12, for example, suggested that, we can't possibly have the Crown having a right of appeal from a court of appeal, then I don't see how you could import as a matter of construction of the section.
Well, let's put it this way, sir. If there is accommodation there in terms of that agreement, I would have to concede that the Crown would probably be included in that appeal, but I did not see it that way, having regard to the.
Yeah, but don't you think you should see it that way, Mr. Hines?
Pardon me?
Shouldn't you see it that way?
I have no difficulty in saying that way if that is the situation. All I'm saying is that I did not view it that way because I did not find anything indicating that that is the way we should look at it. I look at it in terms of the common law situation, which required that you specifically identify the right of the Crown to go to the Privy Council, or if you are not getting accommodation from the Judicial Committee Act, which was in well, there are several acts which were enforced, then you had no right to go to the ultimate.
But Mr. Hines, the purpose of Section 6C is to make sure that any possible error in the interpreting of the Constitution that into which the Court of Appeal may fall will not remain uncorrected. You agree that that is obviously the policy underlying Section 6C?
I would agree with that, sir. I would agree with that.
No, ought it as a matter of common sense and then consistent with that policy, ought it to make any difference whether the effect of the error is to remove a conviction or to uphold a conviction, quash or to remove it? Ought that make any difference to the possibility of correcting it?
Well, on that basis, sir, one would have to concede that the only way you could correct an error which happened below the CCJ level would be to apply the accommodation to the Crown in those circumstances. So I wouldn't have any difficulty with that if that is the reason.
I'm not sure I heard you.
No, I'm saying it is the only way that you can correct an error
Yes.
that occurred below the CCJ level. You have to accommodate an application from the Crown. Well, then so be it. I have no difficulty in going along with that.
Could you, counsel, get any help from Section 2 of the CCJ Act, Chapter 117, where they define appeal and then the cognate expression acronym?
Section 2, I didn't get that one.
Number Section 2 of the Caribbean Court of Justice Act, Chapter 117. You can see it in the applicant's authorities, tab 1.
That says appellate means the party appealing from a judgment.
From a judgment.
But that does not, unfortunately, as I viewed it, that does not tie the appeal to Crown, per se,
Does not tie the appeal to.
to the Crown, or it does not necessarily include the Crown in that definition.
If you would look at the definition of party,
Party means any party to proceedings before the court. Those are extremely wide. I have no difficulty with that, but they do not solve the problem, because this problem occurs all the time. An appeal shall lie. No appeal shall lie unless, and there's no definition of the party that one is seeking to identify. But if the position is that we do have accommodation having regard to the agreement on this matter to include the Crown, I have no difficulty with that.
You see, our attention was drawn to the definition in the Criminal Appeals Act, which limits a felon to a person convicted on indictment. But in this act, there is no such limitation in the definition of appeal or felon.
That is correct, sir.
And the only appeal that is dealt with in this act is an appeal to the CCJ.
Well, it does leave some room, sir, for accommodation of the Crown. That gave me some not sleep.
Do you think that there is some significance in the difference in definition?
Yes, I totally agree with that. But I'm also having some difficulty with the fact that whenever you are dealing with the liberty of the subject in a criminal matter, that you should be hesitant to.
why do you say it's about the liberty of the subject in 6C?
Yeah, I say that, sir, because this application is in fact an application to restore a conviction, and that.
Yeah, well, you see, what I'm saying is that the act itself may not have been dealing with the facts relating to this case.
Precisely.
It's meant to apply generally.
Well, there's room.
So that,
for.
Would you not agree
there's
that?
there's room for accommodation there.
So you would agree that the Crown can appeal under Section 6?
There's room for that, sir.
Yes, well, I don't think we need trouble you on the issue of whether the decision of the Court of Appeal involves a question of interpretation of the Constitution. So perhaps you can go now to the cross appeal. May I ask, if we hold that the appellant has no right of appeal under Section 6C, then I think Mr. Leacock has agreed that that will be the end of the appeal. But in those circumstances, what is your position in relation to the cross appeal?
Your Honor, please, we had adopted the position, sir, that the appeal or cross appeal of the respondent sought to oppose the application of the Crown in that they were asking for a restoration of the conviction. We were saying, in effect, that the quashing of the conviction should be affirmed on the grounds that were set out by the Court of Appeal. But not only that, sir, the quashing should also be affirmed on additional grounds. So, to some extent, the point I'm making, sir, is that our cross appeal is not inevitably linked to the appeal of the Crown.
Why not?
Our cross appeal is in effect saying that
Well, let us analyze it. If we dismiss the appeal, then the conviction will remain quashed.
yes,
What I take it, you would be seeking to challenge would then be merely the order for a retrial. Not so?
Indeed, sir. Only point I'm making is that that part of our argument which seeks to oppose the prosecution would die with that.
Would what?
Our part of the argument which seeks to affirm the quashing of appeal would automatically die
Yeah.
with the death of the Crown's application. But then we would still want to argue against the retrial.
Against
the order for retrial, because
Yeah,
that
but
would
then,
still properly before you.
you would have to get leave from us, would you not?
With the greatest respect, I did not view it that way. We had applied for leave to file an cross appeal in the Court of Appeal, and we obtained that leave.
Well, I don't know that the Court of Appeal, in the event that we are against Mr. Leacock, I don't know that the Court of Appeal would have had any more right to give you leave than to give him.
Well, I would like to respectfully submit, sir, that our application for leave was substantially based on the fact that we intended to argue the retrial as a very significant. We intended to argue against the retrial as a very significant issue. But if the court, this present court, holds a different view, we would then want to necessarily apply for the appropriate leave to mount or retrial arguments, because that is a substantive issue. We are still of the view, whatever happens with the Crown's application, we would still want to argue against the retrial. And if this is the opinion of the court, we would want to apply for leave to continue with the retrial.
You wish now to apply for leave.
We would have to do that, sir.
Well, Mr. Leacock, do you wish to, are you opposing his making an application for leave to appeal against the order for a retrial? There is, we have not had anything in writing And of course, the time has long expired within which such an application should have been made. But I think it was predicated, his cross appeal was predicated on the basis that your appeal had been properly founded. But what do you wish to say in response to this expression of intention or desire to apply for leave to appeal the order for retrial?
Lord, it will be my submission that any such application is much too late in the day, and applying against Maynard's decision, I would oppose it, that I cannot consent to it, and it cannot be properly made at this time.
Yes. You, right, but what the
Yes, sir. If you would, sir, just permit me to.
Just a minute.
Yeah.
All right. Okay. Yes, Mr. Hines, you wanted to say something?
Sir, if you would just permit me to make a point. I would like to respectfully suggest that all cross appeal really is effectively a substantive appeal in the sense that it raises the issue of retrial. And to that extent, I would suggest that, Your Honors, that it could fall under Section 6F. If this is the difficult
Under Section
6F of the Caribbean Court of Justice Act.
6F?
Yes, my lord. Yes, Your Honor. I'm just making this submission because it is, in my respectful submission, is a substantive. I appreciate the difficulty that exists, but if we put it on the if we consider that, or if your lordship would want to consider that it falls under Section 6F, one could conceivably posit that the CCJ no replaces the Privy Council. And under normal circumstances, we would have a right of appeal to the CC, to the Privy Council. We would have a right of appeal.
What is the law under which you are applying then?
So 6F would, in my view, would embrace the Section 37, I think this.
No, I don't want to cut you short, Mr. Hines, but I think you are barking up the wrong tree.
So all I'm suggesting is that normally under Section 37, we would have a right of appeal to the
Privy Council.
And that right of appeal, in my respectful submission now, should fall under 6F, because the CCJ has effectively, for all intents and purposes, replaced the Privy Council. And I'm just suggesting that may be one umbrella under which.
Mr. Hines, there was never a right, even by a convicted person, more or less by someone whose conviction was quashed, to appeal as of right to the Privy Council. And I don't want to ask to waste time. If you are going to apply for leave, then I would suggest that it has to be under Section 8.
As a Lordship, please.
Sorry?
Your Lordship, please. In that case, I would want to make that application in the circumstances.
Well, I tell you, what we will do, Mr. Hines, we will hear you without ruling on whether we will grant you an extension of time for applying. And having heard what you have to say, we will then rule both on the extension of time and, if necessary, on the application itself. So now you can try, you must proceed to persuade us why we should give you leave to appeal against the order for a retrial.
As far as I would want to say that in my view, in my humble opinion, first of all, I would just like to make a formal application for an extension of time for filing a leave application for leave to appeal.
Yes.
In whatever time frame the court finds to be reasonable. But we are saying, sir, that the Court of Appeal effectively made a decision and ordered a retrial. In our view, sir, when you order a retrial, and we set out very clearly in our application, the issues that the Court of Appeal should have considered in ordering that retrial. Those issues are set out in the paragraph 2 of the application dealing with error of retrial, paragraph 2A. We're saying, sir, that the Court of Appeal, the Lordship, did not raise these parameters, these principles, these guidelines that were set out. They did not say to the judges, to the counsel on either side, would you please address us on these issues? What is the murder? Fine, it's a serious offense. But what is the murder rate in Barbados compared to the murder rate in other parts of the Caribbean or the world murder rate? What is the problem with is the accused going to get any difficulty in presenting evidence at a new trial? What's the length of time that would have elapsed between the date of the offense and the new trial? What's the strength of the case presented by the prosecutions? Those are the guidelines that we submit, so were not considered, or the Lordship never invited counsel on either side to address them on, and we respectfully submit, sir, that those are issues, whenever you are going to order a retrial, whenever a court is going to order a retrial, that the court should take into account and deal with them in terms of balancing them or asking counsel on both sides to address the court on it. And that is where we think the fundamental problem is. I do not know if the practice obtains in any other jurisdiction in the Caribbean, but I am submitting that is how it should have gone, and not just to order a retrial. It is true that the court said we have taken the other grounds argued into consideration and the principles and so on, but I think that the counsel should be, in all of these retrial cases, counsel should be required to address the court on these issues because the court might change its opinion after certain issues are brought to the fore. And this was not done. So we're saying there's a real substantive.
But my impression, Mr. Hines, is that it is not normal for the court to invite a submission specifically on the question of whether there should be a retrial or not.
They might not do that, sir, but I'm suggesting that it is the desirable thing to do. Otherwise, the accused really doesn't get a chance to present his case in terms of that decision to order retrial.
You know, Mr. Hines, are we entitled to consider in this the strength of the validity of the basis on which the Court of Appeal quashed fiction?
Well, it is one of the principles that you should bear in mind in not so much the validity, but you may want to come to the conclusion that there's no point ordering retrial because the prosecution doesn't really have a case. But if you don't give the defense an opportunity to explain that, make a submission on it, the court does not have the benefit of that submission.
Do you think that the order for a retrial may have to some extent been influenced by the consciousness of the Court of Appeal that the ground on which they were quashing the conviction was somewhat tenuous?
I didn't get that last part, sir.
I mean, is it really a follow? I mean, I'm just, we cannot interfere with the decision because there is no right of appeal. But is it really logical to hold that arising out of what was said about the man being legally aided, that the jury would regard him less favorably than a man who wasn't legally aided?
Well, I get the point you're making, sir, but I would want to add in connection with that, there's a lot more than that to the matter. For instance, one of the points here that we have raised is the question of right to counsel. In terms of talking about what should have happened, I take the point that, the CCJ is not a retrial court, so to speak. But if you look at what really happened in this case, his lordship at one point made a statement to the jury that this is what it says in effect. This gentleman has alleged he did not see his counsel.
That one?
X visited the police station, sir. Y visited the police station. That is unquestioned. Now, that was said in circumstances where these lawyers visited the police station long after the statement had been made. So we have raised that as in terms of right to counsel. The jury would not know that the right to counsel means nothing if you do not see a lawyer before you sign a statement. And the jury was respectfully completely misled on that because no layman understands the importance of a lawyer before he makes a statement. But his lordship quite clearly indicated that is unquestioned. But he said it is unquestioned in circumstances where counsel appeared at the police station long after the statement was made. And that really cannot be right, sir. So those are the kind of issues that they would want to raise in our submission. And in my view, they're serious issues. There's an issue here where the one policeman, Sergeant Hackett, he's the only person out of 6 or 7 people who went to St. John and arrested the thing. There is contradictory evidence by a police officer of equal rank, a sergeant, I think it was Sergeant Goddard, who said he arrested the man. He arrested the man and took him to the Central Police Station. Now something is wrong there.
Well,
There are a lot of-
one assumes that the Defense Council would have made the most of these contradictions.
Indeed, my lord.
And one would have expected that the judge would have mentioned it in his summing up as well. But I don't think that the judge is under a duty to replicate the sort of address that the Defense Council would have made on this point.
Those are just some of the matters that we thought might be usefully raised at this level, sir. And on that basis, the matter is entirely in your hands.
Mr. Hines, did you request in the Court of Appeal, from the Court of Appeal, whether indicate that you wanted to be heard on the question of the retrial? Did you indicate to them?
I did not appear for the accused.
Oh, you did not. But did counsel appear?
No, they did not, as far as the record goes. This is not the normal thing, but I don't think it really, with all due respect, make any judicial sense if you are going to order a retrial and you do not hear counsel on these guidelines. They should be set up. You have to hear something about the murder rate. You have to hear something about the difficulties or lack of difficulties of a retrial, because that is another procedure, and the accused must be put in a position where he can convince the court why a retrial should not take place. Because sometimes the supervising court comes to the conclusion we cannot order retrial, it's too long, prosecution has no case. Counsel should be given an opportunity to raise those issues in front of the Court of Appeal, not just, with all respect, we order a retrial. We have taken all the grounds into consideration. You can't take the grounds into consideration properly and respectfully submitting unless you hear counsel on the parameters that govern retrial.
Maybe counsel in Barbados should start requesting audience on that aspect.
That is one reason why I'm suggesting it to this court, because if you so rule, we will have it in place yesterday. We need direction, because I do not think you can properly consider and rule on the retrial unless you hear counsel on these matters.
But I think if there are compelling grounds for ordering a retrial, then it's the sort of complaint that you make may not have so much force. I mean, murder is a very serious offense, and the conviction was quashed on the basis of something that was said before the trial started. And, on one view of it, it might be said that the accused was really quite lucky to have been able, through his counsel, to persuade the Court of Appeal that the effect of what was said was so prejudicial that he was denied a fair trial. On this, I'm not sure that the allegation of that someone who is even found to have been forum shopping, as opposed to someone who is alleged to have been forum shopping, is necessarily doing that because he's guilty. I would have thought, as the accused himself explained through his counsel, when your life is at stake, you're not about to take any chances, however innocent you may be. Not so?
Yes, sir.
But in the light of all that, you might have some difficulty in showing that the order for retrial was was such a miscarriage of justice that we ought to take the step of giving you leave to appeal against it.
Out of time now.
You follow my drift.
Yes, I do. I just one of the things that disturbed us about the case, and I think it was mentioned by my learned friend, is the fact too that on the face of the record, and I'm saying it respectfully, the court seemed not to have looked very seriously at the other grounds, and that was really unfortunate. But I'm not pushing that. But I'm just saying that the accused would have had that disadvantage. Put another way, what I'm saying that maybe if they looked seriously at those other grounds, they might have found something. Take the right to counsel. Right to counsel is a critical issue. If the accused does not see his counsel before you come up with the statement, it's knocked out. End of story. But he did not get that benefit. So that's the kind of environment, unfortunately, that I obtained. But I take your lordship's point. And I have no difficulty with it.
Yes.
Could I ask you about the grounds of appeal? According to the judgment, there were 7 grounds of appeal. Judgment of the Court of Appeal. I have seen grounds of perfected grounds of appeal, but there are 9, and the first ground is not the one the Court of Appeal addressed. So I assume the grounds have been amended or.
Yes, sir. The grounds apparently were amended, and it is. I have looked at the record, and it seems to me that your record may not very well reflect the final ground of appeal, except that to the extent that they appear in the Court of Appeal record, but that has been a problem with the recording of documents. So yeah.
So we do not know what those grounds were.
The grounds of appeal should be, the final grounds of appeal should be in the Court of Appeal record. And the ones that came to the court first, I think they were a little misleading. So you should have the final grounds in the Court of Appeal record.
Well, we don't have the benefit of the Court of Appeal's views on any of the other grounds. But what appears from their judgment is that they did not appear to consider them to be more than a sort of big wit, as it were. Something which was tacked on in very general terms to the impact of what was considered prejudicial statements.
I fully concede that, my lord.
So they don't appear to have put a great deal of store by them.
It is just that we thought the CCJ may want to, because of the gravity of the matter, may want to look at those particular aspects, because the issue of the right to counsel, I don't think that was raised at all at the Court of Appeal. But we thought that, the matter might be dealt with here, now that we have an opportunity to ventilate it. But the matter is in your hands, sir.
Anything further? Anything further?
No, sir, no, sir.
Yes, well, thank you, Mr. Hines. Thank you. Uh, Mr. Leacock, there are two things I would like to ask you. One is in response to the point made about the defense counsel not being given the opportunity to address specifically on a retrial. The questions are really, first, whether there is any practice in Barbados with regard to this, and if there isn't, whether or whatever the practice is, whether it should be changed, in your view, to give that opportunity.
Yeah, well, may it please your lordships. Normally, the Court of Appeal hears the appeals, and invariably, they do not ask you to respond or to make submissions on if they intend to order retrial. They normally hear the case, and in their decision, they would quash the conviction and order retrial, or quash the conviction and don't order a retrial, or they might dismiss the appeal. There is no rigid rule as to whether or not they should hear submissions, albeit it might be preferable with the development of the law. And the case I referred to earlier, the Trinidad case that went to Privy Council, Krishna Prasad and Jairam, in which the Court of Appeal had summarily dismissed a case without hearing. I would think that should be the evolving standard that we should follow now, whereby if the Court of Appeal is so mindful to order retrial, that they should invite counsel to address them on it. But suffice it to say, just as I said at the Privy Council in the case on character Michael Huggins 2 years ago, we have no rigid practice on it, and the current practice is that the Court of Appeal makes that decision ultimately on its own if it decides that is in the interest of justice.
But you think that the defense should be given that opportunity then?
Well, I would think both sides. Yes. I would say. Because invariably the Crown would be asking for the appeal to be upheld and for the appeal to be dismissed. And if they are mindful to order retrial, well, maybe they should start inviting the defense to make submissions on that point.
I don't interject in this one to say in my former jurisdiction, we normally did it.
Thank you.
Always ask.
Yeah, I think so. Well, my lord, if I may say one other thing, which you didn't specifically ask, what has been agreed on in this case on both sides, unequivocally, is the unsatisfactory nature of the Court of Appeal's decision. And I think that suggests the strongest basis upon which leave should be granted, so that these matters should be fully argued before this court, so that we can have some proper guidance on this matter.
On what matter?
On the issue as to whether or not this really was a breach of the fair hearing provision. I feel very strongly about this matter because it does create a dangerous precedent for the almost flippancy in which the Court of Appeal accepted some submissions to overturn a murder conviction. And I honestly feel that this court should be able to hear full arguments on these matters, including the arguments raised by my learned friend as to whether or not the retrial should be, and you should be able to make a definitive ruling on the matter, so that the Court of Appeal will have guidance also, and above all, the bar and the prosecution will be guided accordingly, so that we can advise with certainty as to the way these matters should go. This is a very serious matter, and what we can have now is somebody just simply getting up in a court in the presence of everybody without notice and asking for a reclusal, and we could well be faced with this situation all again. It does not inure to the benefit, the best interest of justice, my lords. And I would urge you that you should grant us leave to hear us fully on this matter.
Well, Mr. Leacock, while the court is always willing to give guidance whenever it can, I'm afraid that it would be going quite outside of our functions to hear argument and rule on the validity of the substantive decision of the Court of Appeal to quash the conviction in circumstances in which there is no proper appeal before us against that decision. There is no right of appeal. If there is no right of appeal under Section 6C, and there is no application under Section 8, then it would be quite a gratuitous and I think inappropriate exercise for us to undertake. And I think that your fears as to the consequences of the Court of Appeal's decision are somewhat exaggerated, in that you mentioned earlier that you feared that all that was required now is for the counsel to get up and object to a judge sitting on whatever ground, and he would have to recuse himself. Well, there's certainly nothing whatever in the Court of Appeal decision to justify that. As I said, and the question of whether statements made are sufficiently prejudicial to amount to render so as to render a hearing unfair is a question which the answer to which will depend in every case on the particular statements in question. And if the Court of Appeal has been overly scrupulous in a particular case, it doesn't mean to say that some sort of precedent is set, simply because it will never happen, or very unlikely that it will happen, that those similar statements will again be reproduced in another case. So that I don't think we can accommodate you by going into a full hearing on the substantive merits of the Court of Appeal's decision or making any pronouncement on it.
Much obliged, my lord, except that you are our highest court.
Yes, but we are not an academic court. We deal with actual cases. We don't, in our appellate jurisdiction, give opinions outside the context of issues that are necessary for us to decide. You will have to accept that, Mr. Leacock.
Much obliged, my lord.
Whether you like it or not, I'm afraid.
Much obliged, my lord.
The other question I wanted to ask you is, if this case is to be retried, when is the earliest size that it could be accommodated in?
It would depend on the defense's readiness, and the next exercises where we could be January. Well, we don't call them assizes anymore. But the next session would be sometime in January, provided the defense is ready.
So it could be put for the January sizes. And
Indeed, it could be subject to the readiness of the defense.
yes, well, thank you.
Much obliged, my lords.
Thank you very much. Right, we can give our decision now, and our reasons will be given later. Firstly, with regard to the application of the respondent for an extension of time to apply for leave to appeal the order for retrial under Section 8 of the CCJ Act. In the circumstances, we grant the extension of time and permit the application to be made orally, but we refuse the application, and therefore no leave is given to appeal the order for retrial. And there was the need at all times to apply for leave from this court, and that the absence of such leave is not cured by the mistaken grant of leave by the Court of Appeal. With regard to the substantive appeal and the two preliminary issues which were ordered, which were ordered to be tried. Yes, the first was whether by virtue of Section 6C of the Caribbean Court of Justice Act, the Crown has an appeal as a right to the Caribbean Court of Justice in this case. And we hold that the answer to that is no. We hold that the issue which is raised by the challenge to the decision of the Court of Appeal does not involve an interpretation of the Constitution, and accordingly the second question does not arise. In the circumstances, we have no option but to dismiss the appeal. As I've said, we will give our reasons more fully at a later date. The result is that the decision of the Court of Appeal stands in its entirety, and we order that the retrial of the respondent be fixed for the January 2007 assizes. The offense charged was committed in 2000, and therefore it is necessary that this matter should be retried as early as possible. And we hope that with the cooperation of both sides, this can be achieved. If not in January, next, soon after that, then. Yes, we thank counsel for their assistance.
All right.